house, her stepdaughter asked where the child was, who was 7 weeks old at the time. At that point, my client realized that she had left the child in the car, in the vehicle, and she ran out. Obviously, the inside temperature of the vehicle was extremely hot. She tried to revive the child. EMT officials were called, but the child died as a result of being left in the car. Prior to trial, the state filed a Williams Rule notice, and they said they wanted to get in information or evidence that my client had overdosed on drugs on July 30th, had to report to the hospital as a result of that overdose, and that she had methamphetamine in her system at that time. A Williams Rule hearing was scheduled. At that Williams Rule hearing, the prosecutor stepped back from the position that this was similar fact evidence and said, rather, Judge, we're going to argue that this is inextricably intertwined. Ultimately, the judge agreed with that.
Can I ask you about the Williams Rule issue? And this would, I guess, potentially be, if it applied, a tipsy coachman ground for affirmance. But was there any possibility that this evidence came in to show knowledge or absence of mistake?
I don't think so, and I haven't argued this. I'm going to have to submit it to supplemental authority because the state not only below abandoned that position, but also on appeal is not arguing that this was Williams Rule evidence. But there is a case from the Florida Supreme Court called Robertson that says that tipsy coachman doesn't apply to Williams Rule when the Williams Rule hearing had not occurred prior to trial, because the Williams Rule process requires factual findings to be made by the trial court, and an appellate court, in this case the Florida Supreme Court, is certainly not in a position to make those findings for the first time on appeal. It's something that, because of the state's position, they deprived the trial court from making that determination below, and therefore there's no way this court, under a tipsy coachman theory, could try to say, oh, as an alternative basis for affirmance, perhaps this would have been admissible as Williams Rule. Obviously, I have my thoughts that it wouldn't have been, but that is a matter under Florida Supreme Court case law that cannot be decided at this stage of the proceedings. So what the inextricably intertwined test versus propensity evidence, and I submit this is pure propensity evidence. I think the state almost acknowledges as much in their answer brief at the very beginning. In short, what occurred on September 2nd, 2020 was not a one-time event. The defendant had been using drugs for quite some time. That's propensity. And propensity evidence is not allowed in unless it meets some exception. Generally, it would be the Williams Rule exception. Obviously, the state abandoned that position here. So what the theory, in essence, is it's impossible, or it would be, what's one of the words that the courts use, nearly inseparable for the state to describe the charged conduct and the previous incident. And that's when it becomes inextricably intertwined. That's certainly not what we have here. What was the state able to introduce during the trial? The state was able to introduce that they got a blood sample from my client on the day of the incident, and it came back showing that she had methamphetamine in her system. The state was able to, my client confessed that she had either ingested or consumed methamphetamine 3 days earlier on August 30th. So the state had that as well. The state did a search of my client's residence, and it came back with drug paraphernalia. It came back with some items that showed that there was residue of methamphetamine. The state put on an expert, Dr. Goldberger, who said it was his opinion that my client was in fact under the influence of methamphetamine at the time that the child was left in the vehicle, albeit he said that he reached that conclusion based not only on the concentration of methamphetamine in her system, but also on her actions that day. And on cross, he acknowledged that if he was only looking at the concentration in her body, he wouldn't be able to form an opinion as to whether or not she was affected by methamphetamine on the day of the incident. And of course, the defense in response to all that was, look, she wasn't acting impaired. People came into contact with her. She acted the way any woman who made this horrible mistake would be acting upon finding their child. And that was the issue in this case. It was a close case. But the state presented all the evidence it needed to be able to establish that its theory that she was under the influence of methamphetamine on this date. So again, when you look at the cases that say over and over again how this is not admissible, and I apologize, I've misplaced one of my cases that I wanted to cite to. Oh, they're right here. Goodness gracious. We have the Fitzsimmons case. This is a second DCA case where they said this was a bank robbery that occurred 3 days later, and the court said that the actions outside the South Trust Bank and the subsequent police chase were not so intertwined with the Regions robbery bank that it was necessary to describe them in order to accurately explain the Regions bank robbery. The acts took place 3 days apart. The state did not present evidence that the two incidents were part of a crime spree. We have the Parker case from the 3rd DCA that it's a drug case, and the state was able to introduce evidence of prior drug transactions. And the 3rd DCA reversed and said those prior drug transactions have nothing to do with this incident.
Counsel, you had mentioned that the state had everything they needed. So the jury knew that she had meth in her system. The jury knew about her prior drug use. So why isn't the introduction of the July 30th overdose, given that it wasn't a significant feature of trial, not harmless error?
Did you say given that it was?
Was not a significant feature at trial.
Well, I would disagree with that, Your Honor, respectfully. I think when you look at what the state did present in this case, they put on Dr. Woodham, who was a nurse practitioner, who said that she reviewed the medical records, and she gave very detailed testimony as to what occurred when my client went to the hospital on July 30th. It's on page 22 through 24 of my brief. It's pages 522 through 525, but she goes into great detail about what happened when she arrived there. It was an overdose of an unknown substance, how they took a blood draw, how they used Narcan. Narcan usually relieves opioids, so maybe she had some type of synthetic drug in her system. She was positive for amphetamines, methamphetamines, cannabinoids. And it even went on to this idea that initially she was revived, but then she had a relapse. They had to give her more Narcan, a Narcan drip, and then she ultimately even left the hospital against doctor's orders. All things that certainly paint her in a very bad picture, add to the state's argument overall that she must be negligent, but again, which are completely irrelevant to this charge. Obviously, I've cited to the closing argument, but Mr. Overstreet.
Well, is it completely irrelevant, when we're talking about a case for manslaughter, or we're talking about culpable negligence, in what way does the analysis change when we're talking about things that are inextricably intertwined? When we're not talking about the kind of criminal intent that might be relevant for an armed robbery or something like that, right?
Sure.
So part of what the state is doing is building a case that shows a sort of course of conduct that leads up to this to help to demonstrate that negligence piece.
But that's not necessary to show that she was on methamphetamine on that day. That was all established. So I can think of ways where maybe it would meet this test if the state put on evidence from an expert who said that the methamphetamine in her system from July 30th was still impacting her actions on September 2nd. I wouldn't have an argument to present today because obviously there'd be that link between July 30th and September 2nd. The state could have charged my client with some type of drug offense on September 2nd in addition to the manslaughter, and then perhaps this would be Williams' rule. Again, they abandoned Williams' rule.
But following up, though, on what Judge Long is saying, if there's, like, and it wasn't present here, but say there's like some history of DCF involvement, a series of neglectful actions culminating in a child's death, would not those past neglectful actions be relevant to the ultimate death of the child?
I'm not sure they're inextricably intertwined. I do think timing matters. I think the language from the Florida Supreme Court that I cited from Wright about a clear break matters. The cases that the state's been relied upon are crime spree type cases, and I don't think even in that situation it would be a crime spree. I think you would potentially be getting into Williams' rule if you're talking about previous neglectful acts. Then the state and the defendant's charged with a neglectful act crime. Then I think the state would want to introduce that evidence as prior bad acts and meet the standard under Williams' rule. I think another thing that's missing in this case is if the state had alleged somehow that on July 30th, as a result of my client going to the emergency room because of this overdose, the child, who was roughly 2 weeks old at that time, was neglected, abused, was abandoned, was left alone, no one to care for. That, again, would make it potentially a more difficult argument for me to be raising on appeal, because then you could see the tie to their charging, drug use that leads to neglectful acts towards the child, but we don't have any of that on July 30th. She wasn't still pregnant on July 30th, and that's why I think that's a significant factor. Potentially if there was drug use, and I've conceded regarding the marijuana, my client acknowledged she used marijuana, and she had a valid reason potentially to do so during the pregnancy. But if this was methamphetamine used during the pregnancy, again, that would go to what you're asking about, Judge Long, because you could tie it into the negligence. But July 30th does not have anything to do with the child.
So knowing that the way the drug use has impacted your body and affected your ability to care for yourself and the people around you, and then engaging in that conduct again in this way, isn't that a part of telling the whole story about what happened? And could the jury really have a fair impression of the extent of the nature of the offense if they don't hear about this previous incident?
Two answers to that, Your Honor. Again, there was nothing about her ability, what her drug use on July 30th had on her ability to interact with her child or anyone else for that matter, other than she left the hospital against doctor's orders. So
I mean, being unconscious and not being able to care for yourself wouldn't affect your ability to care for an infant child?
Well, and then the other answer I have to that is then, in essence, you would open this up to, I mean, the state's theory is, which is why this, I mean, propensity evidence is inadmissible. That's clear-cut Florida law. You cannot put on propensity evidence to show that the way that someone acted on this day or previously is consistent with the way they acted on this day. Florida law is absolutely clear about that. That is exactly why they're trying to get this in. That's somewhat what you're asking about, Your Honor.
Well, I think it seems to me there's a distinction between those two things. It's not necessarily saying that just because you consumed drugs here, you necessarily consumed drugs, in time X versus time Y. It's about the knowledge and understanding about that conduct and the way that ultimately affects the state's ability to prove culpable negligence in this particular case, under these particular facts.
Let me rephrase that. Just because she used drugs and that could have caused her to be culpably negligent, for which there's no evidence in this record on previous occasions, and that must mean that she used drugs and was culpably negligent on this day. That's the exact same thing. Whether it's using drugs and using drugs, or using drugs and being culpably negligent and using drugs and being culpably negligent, it's still propensity evidence. And again, I highlight, there's no evidence relating to the child at all on July 30th. No evidence that the child was impacted one way or the other. No evidence that, for all we know, the grandmother was there and was taking care of the child while this was occurring. So there's no link there. But again, if you allow this, where would the line ever be drawn? You would allow this type of drug use forevermore to be introduced. Drug use from a year earlier. Drug use from 4 years earlier.
Well, I think the difference here, and the time is something that I did want to ask Appellee's counsel about, but in the life of this baby, that's not a long time, and it was 16 days after her birth and 34 days before her death. So in that context, in the context of the mother's ability to parent, it doesn't seem like a very long period of time.
The mother's ability to parent. I mean, again, there's no evidence from July 30th about that impacting her ability to parent. We have cases, again, that separate the time and talk about incidents that occurred 3 days later, and the court's saying that's a sufficient break that makes it so it's no longer inextricably intertwined. And again, the idea that it was impossible for the state to present their theory in this case without this, no way, that's not true. The state was able to do everything I just said earlier. They were able to put on that she had methamphetamine in her system. They knew exactly when she consumed that methamphetamine, and they had a doctor testify that she was under the influence of methamphetamine. That's the charged offense. They had everything they needed to be able to prove this case. It cannot be said that it was impossible for the state, or it was inseparable for the state to not have this July 30th incident. And that's not the way they even used it. They used it in closing argument. And this is on page 1090. Miss Rona Garner, Miss Destiny Garner, Miss Lewis, they spent 15 to 20 minutes with the defendant. Skipping forward a little bit, I didn't see anything, but they also didn't know that she was doing meth, that she had meth in her blood. They didn't know that she had overdosed on July 30th of 2020. So what's not happening there? The state's not arguing, this is a pattern, and look, this affects her ability. So the theory that's being discussed up here as to why the state wanted this in, that's not at all what Mr. Overstreet was arguing. Mr. Overstreet's attacking the credibility of various witnesses by saying they weren't even aware that she had a drug overdose on July 30th. And he goes further. Counsel says, well, why didn't you prove that up? Well, I asked Ms. Dauphin, would she like to see the body cam of her overdose? Is she disputing the medical records that showed her that she overdosed? You can weigh her credibility. You can see how these things happened. Now they're attacking her credibility with this. They do the same thing on page 1018. I'm sure Ms. Lewis, the defendant's mother, whether she wanted to admit it or not, knew her daughter had been doing drugs. Okay, and how are you getting to that, Mr. Overstreet? She had known about it in the past. But to suggest that she didn't know anything about just a couple weeks before on July 30th, her overdosing, again, this isn't being introduced for some theory that, look, the July 30th, ladies and gentlemen of the jury, shows that she has, I see that I'm into my rebuttal.
Your time is concluded.
Yes.
We did ask you a number of questions during your rebuttal, so I'm going to give you 5 additional minutes, and of course, provide that to the state as well.
Thank you, Your Honor. I will sit down and reserve the rest of my time for rebuttal unless there's any other questions right now. Thank you.
Good morning. May it please the court.
Morning.
My name is Darren Shippey. I represent the state of Florida in this matter. And you have touched on some things that I plan to touch on, but let me say first of all that we're here today because McKinley is not. She survived 50 days after being born to a mother who used drugs during her pregnancy, as well as after McKinley's birth. The defendant admits and testified under oath that she caused the death of McKinley. And on the day that she caused her death, she told Robin Howell that she was going to go to prison because they drug tested her. Turns out she was prophetic and she was right.
But what's the purpose of the July 30th evidence? What'd that come in for?
I'm going to give you 3 phrases to remember, and then I'll get into some more specifics as it relates to the charge that is very important. Number 1, and you've already touched on it, course of conduct. Number 2, entire context. And number 3, events leading up to McKinley's death. So the short version of that, and then we'll talk about the statute, because understanding the statute that she's charged with is critical to understanding why all of those 3 things I just went through are relevant and why what happened on July 30th of 2020 was relevant. What happened on the 30th of 2020, July 30th, is included in her course of conduct regarding her caregiving of McKinley. From the day that she was born on July 14th until she died on September 2nd, 2020, the defendant was her caregiver. So we can't ignore those 50 days and pick out what we want, what we like and what we don't like.
So, first of all, I mean, it's a tragedy. The kid shouldn't have died. It's awful. So I don't want to be, flippant about this at all. But looking at the True Hill test, where does course of conduct come in under the 4 factors there where they cite to Dorset?
Well, course of conduct is discussed in the statute that she's charged under. True Hill discusses inextricably intertwined. So she's charged under 782.07, which is aggravated manslaughter of a child, which is separate from just the ordinary, what I'll call ordinary manslaughter, where if you try a murder case, it's one of the lesser included. To cause somebody's death when they're less than 18 by culpable negligence by a caregiver, they refer you to Florida Statute 827.032. That's the neglect of a child statute. So you don't get to aggravated manslaughter of a child without neglect of a child. So when you look at that, you'll find that neglect of a child statute, which is essentially incorporated into the information by being referenced into it, is a caregiver's failure or omission to provide a child with the care or supervision and services necessary to maintain the child's physical and mental health, including supervision that a prudent person would consider essential for the well-being of a child. And, importantly, neglect of a child may be based on repeated conduct or on a single incident or omission that results in or could reasonably be expected to result in serious physical injury or mental injury or substantial risk of death. So when you understand the statute under which she's been charged, which takes a second-degree felony of manslaughter and increases it to a first-degree felony, aggravated manslaughter of a child, because she's a caregiver, she caused the death of someone less than 18 years of age, and that death was caused by her neglect.
So are you making an argument, and I didn't see this in your answer brief, or maybe I'm not understanding it, but are you saying that the substantive criminal statute for aggravated manslaughter of a child in some way alters the True Hill test?
No, not at all.
Or changes the relevancy, or how does that play into
The evidence is relevant because of a course of conduct. When you look at the jury instructions that the jury was read in this case, it specifically incorporates course of conduct.
Well, what evidence was entered below that on the date of the overdose, that she in any way neglected her child, her baby?
On July 30th?
Right, the date of the overdose, what evidence
Yeah, it
do
doesn't
we have that-
exist. Doesn't exist.
Okay, and so why is that not relevant to whether there was a course of conduct, when we don't know if, in fact, her ability to parent was impeded in any way?
Because we start back to when she's pregnant. And she's using marijuana, at least documented, 3 times. March, and then just a few weeks before the birth in June of 2020. So there's clearly a history of using drugs, which will go out on a limb and say that no reasonable parent would say that's a good way to take care of your child. And using drugs while you're pregnant with a child arguably could be neglect of that child
Well,
as
and
well.
the marijuana use during the pregnancy came in, so that was in. But Mr. Ufferman's point was that on July 30th, and my point with the DCF hypothetical where, we've got DCF involvement and, kids being neglected multiple occasions, there's nothing tying in the July 30th to the child, is what I'm seeing the problem with it.
Fair question. I'll go back to, we start with while she's pregnant. The baby's born on July 14th. Lo and behold, 2 weeks later, still while she's a caregiver, she doesn't give up her responsibility as a caregiver.
But we don't have any knowledge of that, though. that
But
she's
she has
caring
meth
for
in
the
her
child.
system on July 30th.
Sure.
She has amphetamines in her system. She has THC. It's just a continuation of the marijuana use that she had while she was pregnant. And it culminates on July 2nd when she's also got meth, amphetamines, and THC in her system.
September 2nd, right?
September, what'd I say?
Yes, July, that's okay.
Oh, my bad.
That's
Excuse me.
okay.
Thank you very much.
Sure.
September 2nd. So when you bracket that, and it's only 50 days. She's a caregiver throughout the entire time. She doesn't get a day off even if the baby's not with her. She is a caregiver from before, when she's born, for the 50 days up until the time she admits that she caused her death. She is the caregiver of this child. And throughout that whole time period, which is short, 50 days, she's on marijuana. She's on meth in July, 2 weeks after her baby's born. She's on meth 34 days later when she causes her death on September 2nd. You don't get to say, geez, we can't connect it because there's nothing specific. And one of the reasons we don't know is because she wouldn't talk to the medical staff. She left the hospital after overdosing against medical instructions to do so. And she wouldn't say anything about what happened, probably in part because she was incapacitated. And she only responded, I think it was twice, to Narcan, to even get her to the point where she was probably somewhat coherent. But you don't get a day off as a caregiver when you're using meth throughout the entire 50 days. And it's clear that she is. So it is relevant.
What's your response to Mr. Ufferman's point that, to Tipsy Coachman argument, well, to what extent can the court conclude that this could have been appropriate under Williams' rule? Are there factual findings that were needed that don't exist?
I do not disagree with what Mr. Ufferman has said, that there probably should have been a more complete record in that regard as far as what the statute requires, which is 90.4042. Maybe. But the record certainly would inferentially support the fact that she has knowledge of what impact drugs can cause because she overdosed, although they couldn't determine what it was she overdosed on, except that she responds to Narcan, which reverses opiates, that she has knowledge and is aware. And obviously, there's no suggestion that the meth that was in her system on that day, the THC that was in her system that day, accidentally got into her system. So It's the best way that I can answer that there was not a hearing conducted for the purpose of determining whether or not any of those criteria set forth in 90.404 exists, for introducing it on that basis, which you brought up, I think correctly so, which would be knowledge and absence of mistake. But at the same time, Tipsy Coachman says, is there any basis in the record for upholding what the judge did? And arguably, when you think of Tipsy Coachman and the cases that have discussed it, what we're doing is we're taking a different course from what the judge did. If the judge ruled on something based upon principle X, but principle Y applies, as long as the record supports it, then the court could affirm on that basis as well.
If we think that this is error, whether, 402, 404, whatever, if this came in erroneously, how do we evaluate the harmfulness of the error?
That's a good question, and let me tell you why. The Criminal Appeals Reform Act of '96 places the burden on the defense to establish prejudicial error, and that is error that harmfully affected the judgment. So when I look at it in those terms, did this error harmfully affect the judgment? And then I consider the other evidence, which Mr. Ufferman was excellent at explaining, which includes the fact that she used drugs while she's pregnant. She's got drugs in her system on the day that she caused McKinley's death. She's got an admission where she says, I'm going to prison because they drug tested me. So obviously she knew that, notwithstanding her testimony, which is essentially that, hey, I'm a drug user, but because I'm a drug user, it's like the good alcoholic, I can hold my alcohol. Well, I can hold my meth, right? Except when I can't, when I get distracted, because part of the impact of it is that. And then I leave my child for not 1 hour, doesn't sound like a couple hours, record's not completely clear, but multiple hours to overheat, essentially. And then we consider her own testimony, where she had to explain somehow or another, I had meth in my system, I had THC in her system, although she didn't testify about the THC or the marijuana. And notwithstanding, she had paraphernalia throughout the house, some of which include positive field tests for methamphetamine. She's got to explain that.
Am I correct that Dr. Goldberger is the only one who testified, based on the context of this, that she was under the influence at the time that the baby died?
He is the only person who gave an opinion about it, yes.
But I mean, nobody else said, I mean, because you get lots of trials, yeah, the person was obviously tweaking on meth or obviously crashing following meth use, but we don't have anything like that here. Any appearance of her being under the influence other than Goldberger's testimony after the fact that, based on the levels and the context of a child dying, he thought she was under the influence.
Yes, his testimony. I'll add to that I don't know how to pronounce her name. It's Huene, the person who testified from FDLE.
Yeah.
Her test results were that it exceeded what they were capable of actually identifying, which was more than 200 nanograms per milliliter. She did testify that that's indicative of illicit use. Now, she would not translate that back. She didn't give an opinion. She was very specific. She was not going to give an opinion based upon drug tests alone, but she did testify that the amount that was in, which they couldn't even quantify because it was beyond what their capabilities were, FDLE's capabilities, was indicative of illicit use. So the jury can take that as they want, and there's certainly an inference that if it's...
I mean, any use of meth, though, is illicit use. That doesn't necessarily mean that you're under the influence, right?
Sounds like it based upon what she said, though, if they can't even test that high. So, but any use is illegal. I think we can agree on that.
Sure.
But you are correct. Only witness to come in to testify that, based upon everything that he had seen and heard, in addition to the drug testing that his facility down at the University of Florida did, that her cognitive abilities, and she was impaired by the effects of methamphetamine.
And if we think this was error coming in, given that Dr. Goldberger's testimony was mentioned in the state's close and on rebuttal, how do we say it's harmless?
I'm not, well, he didn't, I don't recall that he got
Well,
into
basically
the,
the-
I don't recall that he got into July 30th. I think the question is whether in the context of looking at all the other evidence, was there prejudicial error that harmfully affected the judgment when you consider the fact that she's got a house that's riddled with paraphernalia, including meth paraphernalia. She's admitted to using it. She admits to causing the death of her child. She admits to using it 3 days beforehand. Whether that's true or not, we'll never know. She admits to having used drugs while she was pregnant. And there is, I think I would take issue with opposing counsel about how much it was discussed in the trial itself. Dr. Woodham came in and was quite factual about what she testified to, didn't render opinions or anything like that. She just was essentially providing what information was in these limited records. So I do not think that there is a prejudicial effect based upon this, particularly when the defense in the case is, I'm a drug user. And because I'm a drug user, I get a pass because I can hold my drugs. And the drugs that I can hold are methamphetamine. She called witnesses herself who seemed to undermine that somewhat. Don't remember the name specifically, but my memory is Michael Garner's mother said that meth was bad or something to that effect. That might be my words, but wasn't a good thing. And obviously she's hiding it from those others because I don't recall that the other family members of Mr. Garner, the child's dad, were aware that she was under the influence of drugs on that day. That may be, like I said, they certainly weren't aware of her situation overall. When made aware of it, that seemed to put things in a different light for them, because then it becomes not just this oopsie situation. And, it is a tragic thing. We can all agree on that. But it's a tragic thing that was clearly avoidable if the caregiver for McKinley, her mom, the defendant in this case, is not using drugs. And she's got drugs in her system on the day of. She was taken to the hospital 34 days before, 2 weeks after the baby's born. She's got multiple drugs in her system at that point in time, to the point that she's completely out of it and has to be revived. She's using drugs during the pregnancy. So when you look at True Hill, I can then connect True Hill and I can say, I disagree that we ought to be viewing this simply as a crime spree case, because in True Hill, they go back to 3 or 4 days beforehand where somebody breaks out of jail in Louisiana. Well, if we're going to use the analysis that, well, you didn't need that to prove the fact that they kidnapped, robbed, and murdered Vincent Binder over in Tallahassee, Florida, I mean, that's a complete disconnect. And that's why I cite True Hill. And it's not just a crime spree thing, nor should we be looking at it that there's some crime spree exception to what the rules of evidence provide for. But going to the inextricably intertwined part, it certainly establishes the entire context and the events leading up to McKinley's death in this case. And the jury instructions specifically talk about, in this case, culpable negligence is a course of conduct showing reckless disregard of human life or the safety of persons exposed to its dangerous effects. Using methamphetamine on July 30th, 2 weeks after your baby is born, is a course of conduct that's reckless. And it goes on to say, it's consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. I don't think anybody in this courtroom is going to jump up and say, you know what? Using meth is a great way to raise your kid. They're going to say the exact opposite. And you know what? It showed up in this case. And we lost a young baby as a result. 50 days after that baby is born, when this mom is using drugs while she's pregnant, 2 weeks after she's given birth, she's in the hospital because she's under the influence that we don't even know what it was, except we know that there was meth in her system. And to continue that course of conduct, she uses meth at some point in time, either on the day of or close to September 2nd. And what happens? That ends the course of the conduct because on that day, as she admits, she caused the death of her child. Thank you. You should affirm.
Thank you, Mr. Shippey. Rebuttal.
Thank you. May it please the court. I'm hoping to make 5 quick points. Let me begin with Candace Wells, a state witness who is an investigator with DCF. She said on page 201 of the record that when she came into contact with my client on September 2nd, she did not believe my client appeared to be impaired from the impacts of methamphetamine. Number 2, regarding Williams' rule, I will submit supplemental authority regarding the Supreme Court case Robertson, but the other issue as to why it's a problem for tipsy coachman is, 1, the state's been referring to this as dissimilar evidence, which is the exact opposite of Williams' rule, not similar fact evidence. So it's almost an invited error situation that the state grabbed the issue away from the judge and said, don't consider it. But beyond that, if Williams' rule evidence is introduced, what happens? The judge instructs the jury for the very specific purpose for which that Williams' rule evidence can be considered. No such instruction was given in this case. Number 3, marijuana. This is really a red herring. The state's theory is not that the child died because of my client being under the influence of marijuana. No doubt, it's in the background in this case. My client admitted to using marijuana to deal with some of the side effects of being pregnant, but that's not the state's theory as to why the child died. Number 4, again, I think what this really comes down to, and it gets to the heart of the questions that we've been discussing, if the state had evidence on July 30th that as a result of my client's drug overdose, this child was neglected, was left alone, was abandoned during that time, or exposed to something else that would cause my client to be a negligent caregiver, I would have a really difficult argument. Because that fits in at least in one of 2 ways. Maybe it's inextricably intertwined. Probably more importantly, that at that point does become Williams' rule evidence. That's a prior similar act of negligence that they would be able to potentially meet the theory under Williams' rule. But that's what's missing. They have the drug overdose, but nothing that links it to negligence relating to the child. We just don't know, and I appreciate Mr. Shippey being candid that there's nothing in this record regarding that. And then finally, why is this not harmless? Obviously, again, I've talked about the extensive testimony that was extremely powerful when it was presented about what happened during that July 30th overdose, what my client's actions were. Again, nothing that was relevant, only painted my client in a bad light. Propensity evidence, it's making her look, as I've argued in the briefs, like a druggie to the jury. But we also have closing, and I've cited to the cases that say that when the prosecutor highlights this evidence in closing, that's something that courts look to see whether or not it's harmless. And again, the prosecutor wasn't highlighting it in closing for the purpose that was being suggested here, that maybe this ties into this continuing pattern of being negligent. No, he was highlighting it to discredit my client and to discredit my client's defense witnesses, that they weren't even aware that she had drug overdose on July 30th. But then finally, it's the Botto case that I've cited in my briefs, and this is what Botto says. The 5th TCA says, evidence of uncharged collateral crimes is not admissible to show a criminal defendant's guilt or propensity to commit a criminal act. The improper admission of similar fact testimony is presumed to be harmful error. Presumed. When you have this type of evidence that comes in, the law recognizes it's different than the other evidence. I mean, the state has a difficult burden in any harmless error standard. It's their burden to show beyond a reasonable doubt that the error didn't impact the verdict. But when you're talking about this type of bad act evidence that's coming in, it's presumed to be harmful. The state has to overcome that presumption. They simply can't, based on the record in this case. I'm simply asking that my client be given a fair trial. This was overkill by the state. They had all the evidence that they needed to present its theory. They should not have presented this additional evidence. Let my client get a fair trial in front of a jury that considers what happened on September 2nd, what happens during the pregnancy, but this July 30th evidence should be excluded. Thank you.
Thank you to both counsel. We appreciate your arguments today. The court is now adjourned.
All rise.
Good job, Mike.